Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. As a result, we upload 10 questions every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click that notification bell so you can be updated anytime we upload new content. Question number 1. Smith and Penn were charged with murder. Each gave a confession to the police that implicated both of them. Smith later retracted her confession, claiming that it was coerced. Smith and Penn were tried together. The prosecutor offered both confessions into evidence. Smith and Penn objected. After a hearing, the trial judge found that both confessions were voluntary and admitted both into evidence. Smith testified at trial. She denied any involvement in the crime and claimed that her confession was false and the result of coercion. Both defendants were convicted. On appeal, Smith contends her conviction should be reversed because of the admission into evidence of Penn's confession. Smith's contention is A. Correct unless Penn testified at trial. B. Correct whether or not Penn testified at trial. C. Incorrect because Smith testified in her own behalf. Or D. Incorrect because Smith's own confession was properly admitted into evidence. Take 10 seconds and choose the best answer now. If you chose option A, you'd be correct. Correct unless Penn testified at trial. The confrontation clause excludes out-of-court statements offered by the prosecution against the defendant in a criminal case if the defendant did not have an opportunity to cross-examine the declarant either when the statement was made or at trial. A conviction will be reversed if the defendant's constitutional right under the confrontation clause to confront witnesses against them is violated. In this case, Smith had the constitutional right to confront witnesses against her. If Penn did not testify at trial, Smith was denied the right to cross-examine him about his confession that was admitted into evidence. Smith's conviction should be reversed for violating the confrontation clause if Penn did not testify at trial. Thus, Smith's contention is correct unless Penn testified at trial. Question number 2. The United States Department of Energy regularly transports nuclear materials through Centerville on the way to a nuclear weapons processing plant and operates in a nearby state. The city of Centerville recently adopted an ordinance prohibiting the transportation of any nuclear materials in or through the city. The ordinance declares that its purpose is to protect the health and safety of the residents of that city. May the Department of Energy continue to transport those nuclear materials through the city of Centerville? A. No, because the ordinance is rationally related to the public health and safety of Centerville residents. B. No, because the 10th Amendment reserves to the states certain unenumerated sovereign powers. C. Yes, because the Department of Energy is a federal agency engaged in a lawful federal function, and therefore its activities may not be regulated by a local government without the consent of Congress. Or D. Yes, because the ordinance enacted by Centerville is invalid because it denies persons transporting such materials the equal protection of the laws. Take 10 seconds and choose your best answer now. If you chose option C, you'd be correct. Yes, because the Department of Energy is a federal agency engaged in lawful federal function, and therefore the activities may not be regulated by a local government without the consent of Congress. Article 6 provides that the Constitution and law made pursuant to it are the supreme law of this land. This clause renders any contrary state legislation void. A state may regulate more extensively than a federal statute, so long as this does not frustrate the objective of the federal statute. A state may not, however, pass a law that excludes conduct that is included in a federal law. States may not regulate federal activities. Here, the Centerville Ordinance serves to prohibit the United States Department of Energy from transporting nuclear materials through Centerville. However, Centerville may not regulate the Department of Energy's transport of nuclear materials because a state may not regulate federal activities. Further, Congress never consented to Centerville's regulation of the Department of Energy's activities. Accordingly, the Department of Energy can continue to transport these nuclear materials through the city of Centerville because the Department of Energy is a federal agency engaged in lawful federal function and is therefore its activities may not be regulated by a local government without the consent of Congress. Question number 3. Dolly is charged with possession of heroin. Prosecution witnesses Walker, an experienced dog trainer, testified that he was in the airport with a dog trained to detect heroin. As Dolly approached, the dog immediately became alert and pawed and barked frantically at Dolly's briefcase. Dolly managed to run outside and throw his briefcase into the river, from which it could not be recovered. After Walker's experience is established, he is asked to testify as an expert that the dog's reaction told him that Dolly's briefcase contained heroin. Walker's testimony is A. admissible as evidence of Dolly's guilt, B. admissible because an expert may rely on hearsay, C. inadmissible because it is based on hearsay not within any exception, or D. inadmissible because of the unreliability of the reaction of an animal. Take 10 seconds and choose the best answer now. The correct answer is A. admissible as evidence of Dolly's guilt. To be admissible, expert testimony must be based on the knowledge, experience, and training of the expert and be beyond the normal experience of an average lay juror. It must be helpful to the determination of the action. It must also be based on proven and reliable data and methods, and must be an application of such methods and data to the underlying facts of the case. Here, Walker's testimony as an expert, based on his experience as a dog trainer, would help a jury understand how the dog's reaction he witnessed indicated Dolly's briefcase contained heroin. Walker's testimony about observing the dog's reaction would serve as circumstantial evidence of Dolly's guilt. Thus, Walker's testimony is admissible as evidence of Dolly's guilt. Question number 4. Owen owned 80 acres of land fronting on a town road. 2 years ago, Owen sold to Buck the back 40 acres. The 40 acres sold to Buck did not adjoin any public road. Owen's deed to Buck expressly granted a right-of-way over a specified strip of Owen's retained 40 acres, so Buck could reach the town road. The deed was promptly and properly recorded. Last year, Buck conveyed the back 40 acres to Sam. They had discussed the right-of-way over Owen's land to the road, but Buck's deed to Sam made no mention of it. Sam began to use the right-of-way as Buck had, but Owen sued to enjoy such use by Sam. The court should decide for A. Sam, because he has an easement by implication, B. Sam, because the easement appurtenant passed to him as a result of Buck's deed to him, C. Owen, because Buck's easement in gross was not transferable, or D. Owen, because Buck's deed failed expressly to transfer the right-of-way to Sam. Take 10 seconds. If you chose option B, you'd be correct, Sam, because the easement appurtenant passed to him as a result of Buck's deed to him. An easement is a grant of non-possessory interest in land that entitles a person to use the land possessed by another. An easement by express grant is a deed allowing the grantee use of the property. If an easement benefits its owner in the use and enjoyment of her land, it is appurtenant to that land. An easement appurtenant requires 2 pieces of land. 1, the land benefited, and 2, the land burden. An easement appurtenant attaches to the land, not its owner, and therefore passes automatically with the dominant tenement. Here, Buck was expressly granted an easement over a specified strip of Owen's 40 acres of land so Buck could reach the town road. This makes Buck's 40 acres the dominant tenement, since Buck's land is benefited and Owen's 40 acres is the servient tenement. Buck's easement appurtenant attached to the 40 acres, so it passed to Sam automatically when Buck conveyed the land to Sam, even though the easement was not mentioned in the deed. Therefore, the court should decide for Sam, because the easement appurtenant passed to him as a result of Buck's deed to him. Question number 5. Lester was engaged to marry Sylvia. One evening, Lester became enraged at the comments of Sylvia's 8-year-old daughter, Cynthia, who who was complaining in her usual fashion that she did not want her mother to marry Lester. Lester, who had too much to drink, began beating her. Cynthia suffered some bruises and a broken arm. Sylvia took Cynthia to the hospital. The police were notified by the hospital staff. Lester was indicted for felony child abuse. Lester pleaded with Sylvia to forgive him and to run away with him. She agreed. They moved out of state and took Cynthia with them. Without the testimony of the child, the prosecution was forced to dismiss the case. Sometime later, Sylvia returned for a visit with her family and was arrested and indicted as an accessory after the fact to child abuse. At her trial, the court should A. Dismiss the charge because Lester had not been convicted. B. Dismiss the charge because the evidence shows that any aid she rendered occurred after the crime was completed. C. Submit the case to jury on an instruction to convict only if Sylvia knew Lester had been indicted. Or D. Submit the case to the jury on an instruction to convict only if her purpose in moving was to prevent Lester's conviction. Take 10 seconds. If you chose option D, you'd be correct. Submit the case to the jury on an instruction to convict only if her purpose in moving was to prevent Lester's conviction. An accessory after the fact is someone who shields, shelters, or assists another, knowing that he has committed a felony in order to help the felon escape arrest, trial, or conviction. The felony must be complete at the time aid is rendered. In this case, Sylvia agreed to run away with Lester after he was charged with felony child abuse. Sylvia took her child, Cynthia, with her, and without the testimony of that child, the prosecution was forced to dismiss the case. As such, if Sylvia's purpose in moving was to prevent Lester's conviction for child abuse, Sylvia is guilty as an accessory after the fact to that child abuse. Let's look at A, B, and C. A, dismiss the charge because Lester had not been convicted. The conviction of the defendant is irrelevant as to the accessory after the fact charge and any charge of that accessory after the fact. Those would be fully separate and apart, and one conviction on the main charge would not be required for a prosecution of the after the fact accessory charge. As to B, dismiss the charge because the evidence shows that any aid she rendered occurred after the crime was completed. That's an odd choice because, in essence, that's exactly what an accessory after the fact would be. So B would not be an appropriate answer. It would almost eliminate itself. And C, submit the case to the jury on an instruction to convict only if Sylvia knew Lester had been indicted. Her knowledge of the indictment is in fact not relevant here. Her knowledge is relevant, but it is with regards to did she intelligently and knowingly, in fact, attempt to aid him in avoiding prosecution. That's the key question. As a result, option D is the only correct answer. Question number 6. The legislature of the state of Chitapa enacted a statute requiring that all law enforcement officers in that state be citizens of the United States. Alien lawfully admitted to permanent residency 5 years before the enactment of this statute sought employment as a forensic pathologist in the Chitapa coroner's office. He was denied such a job solely because he was not a citizen. Alien thereupon brought suit in federal court against appropriate Chitapa officials seeking to invalidate this citizenship requirement on federal constitutional grounds. The strongest ground upon which to attack this citizenship requirement is that A. It constitutes an ex post facto law as to previously admitted aliens. B. It deprives an alien of a fundamental right to employment without the due process of law guaranteed by the 14th Amendment. C. It denies an alien a right to employment in violation of the Privileges and Immunities Clause of the 14th Amendment. Or D. It denies an alien the equal protection of laws guaranteed by the 14th Amendment. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. It denies the alien the equal protection of the laws guaranteed by the 14th Amendment. The Equal Protection Clause of the 14th Amendment applies equal protection to the states. Equal protection is invoked when a law treats one person or class of persons differently from others. The classification of the persons discriminated against will determine the level of scrutiny used. An alienage classification by a state or local government is generally subject to strict scrutiny. meaning the law must be necessary to achieve a compelling governmental interest. In this case, a Chitopa statute requires all law enforcement officers in Chitopa be citizens of the United States. The statute treats citizens differently from non-citizens. Alien was denied a forensic pathologist job in the coroner's office in Chitopa solely because he was not a citizen of the United States. The statute, as applied to Alien, probably does not pass strict scrutiny and therefore probably violates the Equal Protection Clause of the 14th Amendment. There is not likely a compelling government interest in preventing aliens from becoming pathologists in the coroner's office. There's no governmental or political function in that role implicating American values. Therefore, the strongest ground upon which to attack the statute's citizenship requirement is that it denies aliens equal protection of the laws guaranteed by the 14th Amendment. Question number 7. Person sued Dillon for libel. After Peterson testified that Dillon wrote to Peterson's employer that Peterson was a thief, Dillon offers evidence that Peterson once stole money from a former employer. The evidence of Peterson's prior theft is A. Admissible as substantive evidence to prove that Peterson is a thief. B. Admissible, but only to impeach Peterson's credibility. C. Inadmissible because character may not be shown by specific instances of conduct. Or D. Inadmissible because such evidence is more unfairly prejudicial than it is probative. Take 10 seconds. The correct answer is A. Admissible as substantive evidence to prove that Peterson is in fact a thief. Evidence is logically relevant if it has a tendency to make the existence of any fact that is of consequence to the determination of the action more or less probable than it would without the evidence. The substantive law in a given case is the law you look to in order to decide what facts are of consequence. Libel is defamation that is published in durable form, such as written words. If the alleged defamatory statement is factually accurate, however, the defendant has a complete defense to defamation. In this case, Peterson has sued Dillon for libel because Dillon wrote to Peterson's employer that Peterson was a thief. Since truth is a complete defense to defamation, evidence that Peterson once stole money from a former employer would be admissible as substantive evidence to prove that Peterson is in fact a thief. Question number 8. Supermarket is in a section of town where there are sometimes street fights and where pedestrians are occasionally the victims of pickpockets and muggers. In recognition of the unusual number of robberies in the area, the supermarket posted signs in the store and in its parking lot that read, "Warning, there are pickpockets and muggers at work in this part of the city. Supermarket is not responsible for the acts of criminals." One evening, Lorna drove to supermarket to see about a special on turkeys that supermarket was advertising. She decided that the turkeys were too large and left the store without purchasing anything. In the parking lot, she was attacked by an unknown man who raped her and then ran away. If Lorna sues supermarket, the result should be for the A. Plaintiff if supermarket failed to take reasonable steps to protect customers against criminal attacks in its parking lot. B. Plaintiff because supermarket is liable for harm to business invitees on its premises. C. Defendant if the warning signs were plainly visible to Lorna. Or D. Defendant because the rapist was a proximate cause of Lorna's injuries. Take 10 seconds and choose the best answer now. If you chose option A, you'd be correct. The plaintiff if supermarket failed to take reasonable steps to protect customers against criminal attack in its parking lot. An invitee is either a person invited onto the land to conduct business with the owner or a person invited as a member of the public for purposes which the land is held open to the public. The owner of the land must conduct activities on the land with reasonable care as well as inspect the land with reasonable care for unknown concealed dangers. For known concealed dangers, the owner has a duty to warn. If a duty is owed, the owner can satisfy the duty of reasonable care by either making the condition safe or issuing a warning of the dangerous condition. In this case, Lorna is an invitee, so supermarket would have a duty to warn her of known concealed dangers on the land or make them safe. Supermarket was clearly aware of the danger of pickpockets and muggers because it posted signs in the store and in the parking lot warning invitees of this danger. but Lorner was raped, not robbed. Since we are dealing with an invitee, the supermarket has a duty to warn or make safe, and therefore the result would be for the plaintiff if the supermarket failed to take reasonable steps to protect its customers from being raped in the parking lot. Question number 9. Robert walked into a store that had a check cashing service and tried to cash a check for $550, which was payable to him. The attendant on duty refused to cash the check because Robert did not have 2 forms of identification, which the store's policies required. Robert, who had no money except for the check and who needed cash to pay for food and a place to sleep, became agitated. He put his hand into his pocket and growled, "Give me the money or I'll start shooting." The attendant, who knew Robert as a neighborhood character, did not believe that he was violent or had a gun. However, because the attendant felt sorry for Robert, he handed over the cash. Robert left the check on the counter and departed. The attendant picked up the check and found that Robert had failed to endorse it. If Robert is guilty of any crime, he is most likely guilty of A. Robbery, B. Attempted robbery, C. Theft by false pretenses, or D. Larceny by trick. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. That is the best answer, attempted robbery. Robbery is the wrongful taking and carrying away of another's tangible personal property from another's person or presence by force or threat of immediate harm and with the intent to permanently deprive. In this case, Robert clearly attempted to rob the attendant. He put his hand into his pocket and growled, "Give me the money or I'll start shooting." The problem, however, is that the attendant knew Robert and did not believe that he was violent or that he had a gun. So the attendant did not give the money to Robert out of fear. As such, Robert cannot be found guilty of robbery and is most likely guilty of attempted robbery. Question number 10. Dickinson was charged with possession of cocaine. At Dickinson's trial, the prosecution established that when approached by police on a suburban residential street corner, Dickinson dropped the plastic bag and ran, and that when the police returned to the corner a few minutes later after catching Dickinson, they found a plastic bag containing white powder. Dickinson objects to introduction of this bag, the contents of which would later be established to be cocaine, citing lack of adequate identification. The objection should be A. Overruled because there is sufficient evidence to find that the bag was the one Dickinson dropped. B. Overruled because the objection should have been made on the basis of incomplete chain of custody. C. Sustained because Dickinson did not have possession of the bag at the time he was arrested. Or D. Sustained unless the judge makes a finding by a preponderance of the evidence that the bag was the one dropped by Dickinson. Take 10 seconds and choose the best answer now. If you chose option A, you'd be correct. Overruled because there is sufficient evidence to find that the bag was the one that Dickinson dropped. Please remember, every item of non-testimonial evidence must be authenticated. The burden of proof is sufficient to sustain a finding standard, i.e., could a reasonable person believe this item is what you claim it to be? This is below preponderance. Therefore, if there is a conflicting evidence as to the authenticity, all of it is admitted and the jury must decide who to believe. In this case, the prosecutor established that when Dickinson was approached by police on a street corner, Dickinson dropped the plastic bag and ran. The prosecutor also established that when the police returned to the corner a few minutes later, they found a plastic bag containing white powder. A reasonable person could believe the bag found on the corner was where Dickinson had dropped the bag a few minutes earlier was in fact the bag that Dickinson dropped. Therefore, the objection should be overruled because there is sufficient evidence to find that the bag was the one Dickinson dropped. As always, thank you for joining us on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content.